further privilege now to introduce our second distinguished speaker for this session, Professor Neil CRAIK. Professor CRAIK is a renowned professor at the University of Waterloo, with appointments to the School of International Affairs and School of Environment, Enterprise and Development. His expertise lies in the fields of international and Canadian in environmental law. Professor CRAIK currently focuses on the legal structure of global commons regimes, with a keen interest in deep-sea mining regulation, climate and geoengineering law and governance, and environmental impact assessment. He brings a wealth of knowledge and insights to the table. As a prolific scholar, Professor CRAIK has co-authored books such as Liability for Environmental Harm in the Global Commons and The International Law of Environmental Impact Assessment. His contributions to the field of environmental law have been widely recognized and respected. Additionally, Professor CRAIK serves as a senior fellow at the Center for International Governance, Innovation, and is the co-director of the International Law Summer Institute. From 2011 to 2017, he also held the position of director of the School of Environment, Enterprise and Development at the University of Waterloo. Today, Professor CRAIK will be sharing his expertise through a presentation titled Environmental Impact Assessment under the BBNJ Agreement, Institutional Dimensions. With his deep understanding of the subject matter, he will provide valuable insight into the institutional aspects of AI within the framework of the BBNJ Agreement. Professor CRAIK, you have the floor.
Thank you very much, Judge Kulik. And let me also add my great appreciation to the organizers of this event, the Korean Foreign Ministry and the Korean Society of International Law. I feel like I may be ruined for conferences for the rest of my life because I don't think I'll ever be treated quite as well at a conference as I have been at this particular conference. So I'm deeply appreciative of all the efforts of all the people who've put this together. And it's a real privilege for me to share this stage with such knowledgeable colleagues, and I look forward to the discussion. My focus today will be on the institutional dimensions of environmental impact assessment. Institutions play a number of important functions within EIA processes, but my proposition today is that in the high seas context, institutions play an indispensable role. And the design and carrying out of these functions will, I think, be crucial to the success of the high seas EIA rules. And I say this for several reasons. First, in international law, EIA implements the duty to prevent harm and the duty to consult, but in the high seas context, these obligations are owed to the international community as a whole. Individual states and other relevant stakeholders have divergent interests. As such, there is a need to aggregate and collectivize those interests and to manage and facilitate interactions among these actors. Second, the knowledge environment in the high seas context is characterized by deep uncertainty. The biophysical systems of the ocean are complex and subject to large-scale environmental changes due to climate change, biodiversity loss, and endemic pollution. Baseline data is scarce and held diffusely. There is high potential for considerable information asymmetry between project proponents and oversight authorities. In addition, the predictive capacity of EIA is further constrained by cumulative and synergistic effects. This suggests a role for managing and interpreting data as well as managing uncertainty through monitoring and adaptive processes, and in the case of cumulative effects, integrating data across multiple projects and multiple sectors. Third, the normative landscape remains vague, requiring elaboration of open-ended standards such as minor and transitory effect and significant adverse impact. And I think you heard a lot about that from René. There's an important role here for the generation of consistency and coherence in EIA rules, and again, that requires an institutional intervention. Finally, the sources of regulatory direction are fragmented and may draw across different international, regional, and national institutions and may require active integration. In domestic contexts, projects are subject to comments across multiple agencies with different mandates and different responsibilities. And here again, there'll be a need for institutions to engage other international institutions and manage that for the purposes of coherence. So institutions play an important role in addressing these functions, but very much depend upon their structure and capacities. The role that institutions play in EIA processes are dependent upon how we understand the way in which EIA affects environmental outcomes. Unlike traditional command and control approaches, EIA does not dictate particular outcomes, but rather identifies environmental goals in abstracted ways and requires adherence to procedural requirements. EIA compensates for a lack of substantive specificity through procedural specificity. The famous line from the US Supreme Court is that EIA prohibits uninformed but not necessarily unwise decisions. The assumption that underlies EIA is that requiring proponents to investigate the potential impacts of their proposed activities in a transparent and participatory manner will result in environmentally desirable outcomes, which are explained as arising through several pathways. But by what mechanism does adherence to procedural requirements result in particular substantive outcomes? And I think there are three potential pathways. The first, and perhaps the sort of standard understanding of EIA, is the informational approach. Effectively, decisions respecting planned activities are driven by scientific and technical analysis. More and better information about future impacts will lead to environmentally sound decisions. This model relies on high predictive capacity and treats environmental goals as determinative and uncontested, and trade-offs as being objectively determinable. In other words, there exists a common understanding of the public interest, and decisions consistent with that understanding can be determined through the systematic and comprehensive study of effects. The second approach accepts that EIAs mediate between competing interests, and that proponents or authorizing states will pursue their own interests in the absence of incentives to alter their position. EIA processes, however, may structure bargaining and alter incentives in ways that push decision makers towards more acceptable outcomes. Transparency and participation are key to these processes as they facilitate reciprocity by allowing states to monitor the actions of treaty partners and enable stakeholders to exert pressure on proponents. I think it's important to note here that reciprocity works quite differently in the commons, or potentially works quite differently in the commons than it will in transboundary contexts. In transboundary contexts, states are quite motivated to manage reciprocity because if they impose impacts on a neighboring state, they may be subject to those same impacts themselves. In the commons, it's a slightly different calculus because they can benefit from activities, but when other states impose impacts on the commons, that's a much more diffuse impact on the state and upon domestic interests within the state. These political processes and mechanisms are more likely to be affected if there are venues that allow for political mobilization or the operationalization of reputational concerns, or where stakeholder groups can impose costs through mechanisms like judicial review. I think the most convincing reading of the history of EIA is that EIA processes tilted the playing field in favor of environmental interests because of the threat of litigation, delay, and reputational damages, and push those companies towards environmental compromises. A third approach emphasizes social learning. Here, the interests of states and other stakeholders are not fixed, but can be transformed in light of new factual and normative information. EIA processes that are discursive and require justification in light of environmental information, public comments, and environmental goals have the potential to socialize actors because they project scientific information and scientific norms into administrative processes. States that are required to justify their planned activities in light of this information may begin to internalize these norms. Proponents do not abandon self-interest, but they may recalculate interest over time. And again, I think if we look at the origins of EIA, EIA was originally created because agencies were issuing decisions and not taking any account of environmental matters. Agencies were building roads, building dams, and it wasn't really their mandate to look at the environment. This is in the sort of 50s and 60s. And then EIA was a way in which to force those agencies to begin to account for environmental impacts in the decisions that they made. But over time, and there's been a fair amount of empirical study on this, over time, those norms actually become internalized within the agencies. They recognize that actually protecting the environment is actually consistent with their mission to produce the things they want to produce. But it's very longitudinal and requires iteration over repeated interactions. I think from an institutional standpoint, the key point here is not which theory of EIA is right. All of these pathways will operate to a greater or lesser degree, but their effectiveness in generating desirable outcomes will depend on the extent to which other elements of the EIA process are present within the institutional structures of EIA. What is the capacity of the EIA institutions to review and evaluate scientific and technical information? Are there clear evaluative criteria? What are the conditions of transparency? What information is made available? When is it made available? How long do participants have to prepare responses? To what degree do the interactions require justification and reassessment? And so turning to the agreement, the institutional arrangements surrounding EIAs compared with other international instruments are quite elaborate and on the face of it appear quite robust. They involve 5 principal institutional structures plus the International Tribunal of the Law of the Sea. And I will speak to principally 3 of these today. The Conference of the Parties is the plenary body and the only political body within the treaty structure, but does not engage directly with project-specific EIAs. There is no approval authority such as that exercised by the ISA, and unlike the Committee for Environmental Protection and the ATCM under the Antarctic Treaty System, which have the opportunity to receive and consider EIAs, there is no opportunity for formal or informal consideration of EIAs before the COP, which has implications for the extent to which political pressure may be brought to bear. Also has implications for the perspective to which the COP gets exposed to different stakeholder positions, and I think importantly, different positions around different ways of knowing and traditional knowledge. Instead, the COP engages in the EIA process through the development of standards and guidelines. This is an important role which provides potential opportunities for the parties to consider and debate the interpretation and application of key regulatory concepts such as thresholds and cumulative effects identified in Article 38. There is a more direct role for the Conference of the Parties in strategic environmental assessment. The COP's role is directed towards regional or area-based SEAs and may therefore provide an opportunity to generate shared goals. The wording of Article 39.2 suggests a somewhat technical approach. It talks about collating and synthesizing the best available information, assess current and potential future impacts, identify data gaps and research priorities. Nonetheless, Article 39.3 requires SEAs to be taken into account And so there's a tiered approach. SEAs will influence and have to be taken into account for project-specific EIAs. And so SEAs may play a loosely prescriptive role. Finally, the COP has an important constitutive role in setting the roles and modalities for the scientific and technical body and the clearinghouse mechanism. Let me turn to the scientific and technical body. It is an expert body, but interestingly, attention is paid to the representation in its formation. There's a recognition of the complex politics around the science policy interface, and a recognition that the legitimacy of scientific advice depends on the perspective and ways of knowing that are represented within the scientific and technical body. It is the only treaty body that reviews and comments on individual EIAs, and there are 3 points of intervention. So if we think of an EIA process as screening, scoping, the draft EIA, the final EIA, the decision, and then post-decision monitoring, the points of intervention are screening, the draft EIA, and then in monitoring. The scope of review is unspecified, but could range from quite technical reviews for compliance or more substantive reviews of the quality of the assessment and conclusions drawn from it. My reading of the agreement is it appears the intention of the party was to be the latter, but that could be affected by subsequent rulemaking. The STB exercises only persuasive authority through recommendations and is able to draw on outside experts. And I think this will be interesting because I'll come back to this, but I think there's a serious question around capacity. If it turns out that there is a lot of EIAs and a lot of monitoring, then the STB will be under some pressure in terms of its ability to just manage the workload in a practical way. And remember, these types of activities in domestic EIA are undertaken by full-time large bureaucracies, not groups that meet at sessional times. And we're even seeing in the deep seabed process at the LTC is having to do more and more intersessional work and is facing those issues. The STB exercises high levels of discretion in connection with its powers of evaluation and comment, and the wording is really quite important here, where the treaty says the STB shall consider, and then what the SDP may do. And this points to the importance of the internal decision-making of the STB. And so will they be making decisions by consensus only? Will they be making decisions on a majoritarian basis, looking at other groups like the LTC in the deep seabed process? Their rules of procedure call for striving towards consensus, but do have a majoritarian voting structure within that. I think it also raises questions about what will govern the discretion of the scientific and technical body. And so if they're deciding whether to evaluate a particular EIA or whether to issue recommendations, then what is actually going to govern that particular discretion? René Lefebvre mentioned the call-in mechanism. It's a new term for me. And I think this is really quite an interesting role for the STB because it inserts itself to some degree in a dispute between states with respect to screening and also with respect to monitoring, because it arises when a state makes a determination as to screening and another state registers views, and then the STP is called upon to consider and potentially evaluate, and potentially make recommendations. And so again, this is quite a unique role for a scientific and technical body to insert itself into disagreements between states as to the application and implementation of the treaty. The STB also makes recommendations on policy matters, standards, and guidelines, and so will have an influential role as an originator of policy directions within the treaty. The transparency rules under Article 48 note that all meetings of subsidiary bodies are open to observers unless otherwise decided, and observers may request rights of participation. And this has some potential to turn the STB proceedings into a sort of form of deliberative fora. Again, I think it's worth thinking about the degree of openness of subsidiary bodies. This has been a growing area of concern in the ISA, where the LTC's meetings are largely closed. Drawing the boundaries around openness is not straightforward in my view, as there is merit in allowing technical bodies to deliberate among themselves and with candor. Different decisions may require different levels of openness. For example, in their policy creation role, openness may be quite appropriate. There is, as far as I can see, no duty to give reasons when the STB exercises discretion. It doesn't necessarily have to provide reasons for its decisions, but that may be clarified on the rules of procedure. Let me turn quickly to the clearinghouse mechanism. Now, the clearinghouse mechanism is a platform, but its design may shape the effectiveness of the EIA provisions. How much information is shared? Will the underlying data be made available? What baseline data will be made available? How long will it be made available for? How accessible is it? And to whom is it accessible? And I think importantly, how will the rules on confidentiality impact the level of information that's made available, and who determines the validity of claims of confidentiality? Article 51.3 speaks to enabling access to parties to the clearinghouse mechanism, but is silent on other stakeholders. Compare that with Article 48.4, which says that there will be timely access to all relevant information to stakeholders. So I think the intent is to provide access, but the rules provide potentially some opportunities to shape that. Just sort of moving away from the institutions themselves and thinking a little bit about what the institutional structure means for EIA. And my first point is that the institutional functions are consistent with the primacy of state sovereignty over activities in the high seas. There is no approval function or ability to attach conditions. The STB makes recommendations only. It exercises persuasive authority. States maintain a central role in the review of EIAs, and ultimately, the EIA process is a domestic process to a large degree. Consistent with transboundary EIAs, there is a right for other states to have their position accounted for, and I think an interesting question will be the extent to which states will have incentives to register concerns. There may be incentives not to register concerns, and I think the role of observers in civil society will be crucial to the ability of the EIA process to continue to exert pressure on proponents and proponent authorizing states, including those beyond coastal states. The EIA provisions, as I noted, are oriented towards encouraging state due diligence and the duty to cooperate. And I think the role of the STB recommendations may have some important impact on the determination of due diligence. The ultimate decision that states have to make with respect to planned activities is made through the lens of due diligence. And so again, I think there's an interesting role in terms of the legal understanding and legal development of due diligence. The impact of recommendations that aren't followed on due diligence is probably worth thinking about. What does it mean if the STB makes recommendations that aren't followed? If they're reasonable, is that grounds for suggesting that the state hasn't acted with due diligence because there were reasonable grounds they could have taken to limit the risk of harm? If harm actually arises and there were recommendations that were made that weren't followed, does that impact on due diligence in some particular way? I think the role for standards and guidelines will be quite important in terms of setting the expectations around due diligence. I think the other important, and I would say shift with the rules on EIA is the move away from a reliance on ex ante prediction in favor of a more regulatory approach that relies on monitoring and reporting. I think there's a recognition of the epistemic limitations of prediction in the deep oceans, and as a result relies on the authorizing state and the STB to review and respond to monitoring reports. There's a potential sort of enforcement role that the STB plays here because monitoring reports go to the STB and it has the opportunity to evaluate those and make determinations as to whether a potential for significant impact arises. And so again, quite an expansive role for the STB. Monitoring and reporting relies on the ability for adaptive management. So the idea is that if you monitor and you find that the activity results in unexpected impacts or impacts that are greater, then the expectation is that the state will change what they're doing in some manner to reduce those impacts to levels that are in compliance with their international legal requirements. This requires some attention to the degree of flexibility that states have in ensuring that they can actually change activities. So that involves the extent to which when they're granting approvals, whether those approvals result in any vested rights. And here I'm thinking quite particularly of the security of tenure provisions in the deep seabed mining, which potentially makes it harder to do adaptive management because you need the contractor's consent in order to change the plans of work. As I mentioned, the monitoring and reporting provisions could in particular result in capacity challenges because of the potentially large scope of this. When you read Article 35, it's quite wide. It's not restricted to monitoring and reporting on those activities that were subject to a environmental impact assessment that went through the process under the Act, but all activities. So it could even include activities that were screened out, but then subsequently were found to have a more significant impact. Again, I think SEA could play a critical role in shaping the environment here. It provides an opportunity for a collective and integrated approach. It shifts away from a focus on due diligence and more towards integration as the animating principle. And so I think SEA as a way of thinking about integrated oceans management is particularly important. There is an interesting issue around SEAs and equivalency. And so if you have an exemption due to the equivalency provisions in the treaty, will equivalency be impacted by the presence of an SEA? In other words, does an equivalent EIA have to account for an SEA that's been put in place by the conference of the parties? Or does equivalency, if you have an equivalent, so does a EIA under the deep seabed mining regime have to account for a strategic environmental impact assessment that is in the same location, or is it good enough that it complies entirely, is it an entirely self-enclosed provision and follows the regional environmental management plans of the ISA? I think, again, that points, and I'll come back to this, to the importance of interinstitutional cooperation. I think that the provisions around interinstitutional coordination are, again, particularly important and critical for realizing integrated oceans management. There's a number of provisions that I think are important. One, of course, is that other international and regional bodies can engage the BBNJ EIA process as observers. Under Article 32.3, regional and global bodies are defined as stakeholders, but they cannot register views, which is reserved for parties. In some ways, one might hope that international bodies could function to some degree as commenting agencies. And again, if we draw an analogy to domestic EIA, what happens is that one agency may undertake an EIA, but it circulates that EIA to other agencies that have different kinds of expertise in their respective area. Should the STP, for example, provide input on the biological diversity dimensions of an EIA conducted under the ISA's regulation in connection with a new mining license? And I think the answer is, on a positivistic standpoint, that it will not, but I think on a normative level, it may make some sense. And it could be structured through the formal collaboration measures under Article 29. Here, the COP develops the mechanisms, and there's was some mention of the possible analogies or existing processes, and so the OSPAR collective arrangements, I think, is perhaps the clearest mechanism for cooperative arrangements between international institutions that involve impact assessment, which they do. The STB would be the collaborating body, so while the COP would set up the mechanism, the STB would be the collaborating body. And again, it could share data, co-develop standards and guidelines, and possibly coordinate strategic environmental impact assessments. If I can just return to the issue of EIA effectiveness, my first observation would be that the central role of the science and technical body suggests an orientation towards the informational approach. But the capacity of the STP to be effective depends on scientific and technical capabilities. But their capabilities will be spread quite diffusely because the STP is not just looking at EIAs, it's looking at a range of things and will require a large scope of expertise. The limited workload capacity may shape the form of review. The role of the parties and stakeholders is less consistent with the informational approach. I think there's an instrumental role for parties and stakeholders to provide just valued information that can improve the scientific value of the EIA, but it's very clearly that the intent is to do more than that, is to provide deliberative and normative input into these processes. I think the information theory is very clearly in tension with the epistemic and normative conditions in the deep seabed. In my view, there are no clear right answers. This is not to say that science is indeterminate, but it just means that it is not likely to dictate outcomes. Turning to pluralist theories, the transportation and consultation measures suggest a recognition that decisions must account for other interests, but the forms of interaction exist largely outside political fora. I hadn't thought about the point that René Lefebvre mentioned about moving things to the agenda of the COP as a possible way of elevating it, and I suppose that's potential, but I'm not sure that that would actually get a review on a specific, project-specific EIA, but potentially it could. The STB becomes a possible site for contesting EIAs and a possible deliberative fora, but the question really is that fora going to enable for political mobilization and the leveraging of reputations? And where will those perspectives matter? And will they matter more in the domestic process or in the international process? Because again, it's really a two-level structure. Ultimately, the EIA is informing a decision that's being made within a domestic fora. In terms of transformational theories, there is certainly a deliberative quality, and there is certainly a number of places in the agreement that require for public justification of decisions. And so I think it will add, and there is a discursive quality to the interactions in the sense that parties can register views and provide information. The proponent party has to respond to it and presumably account for these other positions. And so there is an iterative and discursive quality. I think the most interesting provisions are actually around the opportunities for learning, with the high emphasis on using past EIAs to inform practice and to inform ongoing normative development. And so there's quite specific provisions in the agreement that require the STB to continually look at EIAs and consider what they can learn from them and how they can improve the process. And I think that will lend itself potentially to a degree of social learning, as will, I think, the SEAs. And just to sum up, as I suggested at the outset, EIA does not rely on one mechanism or pathway to influence outcomes. But in that regard, I think that is really the genius of EIA provisions. EIA doesn't remove politics or state interests from decisions, but what EIA does is it pushes actors towards a certain kind of politics, a politics based on science and shared values. And so at its best, I think EIA shapes those values, but of course much depends on, and this is my main point, much will depend on the interaction between the structures and then the actors within those structures. Thank you.
I thank Professor CRAIK.